back. And we're going to look at today federal regulation of funeral billing and collection. We like to get paid. Funeral homes are subject to several consumer protection and disclosure measures that regulate billing and collection. Truth in Lending Act, the Magnuson-Moss Warranty Act, Credit Practices Regs, and the Gramm-Leach-Bliley Act. So TILA, the Truth in Lending Act, this is one of the big ones. Purpose is to ensure that consumers who are provided credit by banks and businesses are fully apprised of all aspects of the credit arrangement. Some funeral homes do extend credit to their families, and there is no exemption for funeral homes from the Truth in Lending Act. So if you fall into the category, you have to comply. You're required to make Truth in Lending Act disclosures during any particular transaction that satisfies the two-part test. If you qualify as a creditor under the regulation, that's one, okay? Or extend credit to the consumer. Both must be applicable. If you extend credit but do not qualify as a creditor, you're not required to make the disclosure. So who is a creditor? A person or business which extends consumer credit more than 25 times in a year, based on transactions in a calendar year or in the current year, but not both together. Now, if you qualify as a creditor based on transactions in 2012, you are a creditor for all of 2013. So the trigger is as soon as you hit 25 credit transactions, okay, you become a creditor for the remainder of the year you're in and the extension of the following year. Okay? The instant you reach 25 credit transactions, you become a creditor, no matter if you were one or not at the beginning of the calendar year you're in, and you remain one for the following year, even if you don't make 25 cases in 2013. I know this is complicated. So, 2012, July, you hit 25. July 1st, you make your 25th credit transaction. You are now a creditor. The remainder of 2012 must make all Truth in Lending Act provisions. You will make Truth in Lending Act provisions throughout all of 2013, but we'll say during 2013, you only do 12 acts, 12 credit triggers, okay? On January 1st, 2014, you are no longer required Truth in Lending Acts because you are no longer considered a creditor. Does not matter if you're oral or written. As long as you make a contract that provides credit, you're busted. You become a creditor whenever you impose a finance charge in a transaction with a natural person or enter into a written agreement with a natural person that calls for payments in more than 4 installments. Notice that natural person. If you extend credit to companies or corporations, that is not the same. It has to be individual. This is consumer level. If you are extending credit to corporations, trustees, guardians, nominated person representative, etc., you do not count as a natural person. Remember, when you act in the capacity of the office, you are not acting as a natural person. Disclosure must be made to the natural person. So even if you are a creditor, you do not have to extend the disclosures to a party that is not a natural person. So what is a finance charge? When you charge a financing fee, you are extending credit. The two common fees that we do charge are late charges and discounts for prompt payment. If the consumer is not making planned payments, you are not extending credit. So a late fee is generally not considered a finance charge. Invoice or bill must state that the entire amount is due by a certain date, and if not paid, late charges will result. Earlier in a separate lecture, we saw about this is a cash transaction. This is what this applies to, okay? You're not extending credit. You must enforce your late charges on a very consistent basis, or else you might be deemed to be extending credit. People are late with payment, hit them for the fees. Better yet, just get paid up front and not worry about it. Warn your consumer, letter, phone call, that an amount is overdue, penalties are being assessed. Establish your collection process and stick by it. Do not refer to the late charge as anything other than what it is. Interest charge, finance charge, carrying charge, service charge. It's not. It's a late charge. Call it what it is. So discounts. As of the 2011 version of the book, clarification of the Truth in Lending Act now indicates that a discount does not constitute a finance charge. If you have an older book, the 2003 version, for instance, it's a change here. $2,500 bill. Family has 30 days to pay, under which they receive a 5% cash discount. And the Truth in Lending Act, under previous editions of the text, would be regarded as a finance charge. Okay? Not now. If a discount is given for immediate payment, cash, check, credit card, whatever, it is not considered a finance charge under any edition of the book, and this must be available to all customers. So if you're giving them a 5%, sign it, seal it today, that is not a carrying charge. Okay, that is not a finance charge. Under the new edition, the clarification, it is also not if it is a 30-day 5% discount sort of thing. Okay? Generally, pre-need contracts that are paid for over time where there is a finance charge or more in 4 installments are considered extensions of credit. So, memorize that. If you're paying a pre-need contract that assesses a finance charge, or it's more than 4 installments, you are generally extending credit. If you list credit terms, you're governed by the Truth in Lending Act. Okay? 2 requirements. Specific credit items listed in the advertisement must be the terms that are or will be arranged. So if you say, hey, 3% finance rate, you actually have to do it at 3%. So if your advertisement lists amount of a down payment, amount of any installment payment, number of payments, length of payments, or a finance charge, you must then comprehensively list amount of down payment, terms of repayment, annual percentage rate, must use the whole term, not just APR, and if it is a fixed or variable rate. If you refinance a transaction, a whole new set of disclosures must be made. A refinancing occurs. A credit transaction is replaced by a new one. An extension or a deferment does not require new Truth in Lending acts. You're extending an original. The terms haven't changed. You're deferring an original. The terms haven't changed. If the terms change as a result of a court proceeding, new disclosure is also not required because, the court has listed them out for you. So an extension or deferral does not require the issuance of a new set of disclosures. Various minor disclosures must be made if a fee is charged as a result of the extension or referral. Credit obligation is not one in which the finance charge is determined simply by the application of a percentage rate to the unpaid balance. In this event, the creditor must set out the amount of the fee, the amount deferred or extended, and the date to which the payment is deferred or extended. So required disclosures must appear in a separate form other than the funeral bill or contract. It must be made prior to the performance of the sale, signing of the contract. And this makes sense. You want them to agree to the terms of the contract before they actually engage into the contract. If you do it vice versa, you might have, fraud in the inducement, a way to void the contract. So under the amount financed, you have 2 disclosures. Must be told the exact amount financed, cash price, etc., etc., etc. And itemized statement by the funeral home of the amount financed. Basically, your statement of goods and services must be separate from all other disclosures. You must list what amount was distributed directly to the consumer, what amount went to the payment of any prepaid finance charges, what amount was credited the consumer's account with the funeral home, blah, blah, blah. Lord almighty. Cash advance would need to be listed separately. Again, the name of each of the advances, newspaper name, florist, minister, blah, blah, blah. Can you see why it's almost not even worth offering credit in all the places this can go wrong for you? In place of itemization, the funeral home may provide a statement informing the consumer that they are entitled to a written itemization and indicate a spot where it can be requested. If they elect not to have one, you do not need to itemize it out as described above, which you can probably bet your bottom dollar that this is the way most firms go. Finance charge, you need to disclose the amount which you are charging to extend credit. Whoopsie. Must be referred to as the finance charge and explained as the dollar amount the credit will cost you. The finance charge is a total of all credit costs, including interest, service charges, carrying charges, loan fees, blah, 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 blah. Insurance must be included as part of the finance charge unless they are disclosed separately. Do not include taxes, license fees, legal fees, registration fees, things like that. If the amount financed is $1,000 or below, the finance charge stated is within $5 of the actual charge, it's deemed accurate. If it's above $1,000, the tolerance extended to $10. Ooh, lucky you. When you refer to the annual percentage rate, you must use the term annual percentage rate and explain it as the cost of your credit as a yearly rate. If it can be increased after the sale, list the conditions in which it can increase, the amounts as well as an example of the payment terms that will occur as a result of the change. It is considered accurate if it is not more than 1/8 of 1% above or below the actual percentage rate. For irregular transactions, payments that are not equal, the tolerance is permitted to 1/4 of 1%. Creditors are permitted to disregard months that have different numbers of days in the occurrence of leap years. With the payment schedule, you must disclose the number, amount, and timing of all payments. And if there are no maturity dates, the funeral home must disclose the due dates for interest payments for the first year only. If payments vary, you must disclose the largest and smallest payments in the series and explain the payments may vary. You must disclose the sum of payments under a heading listed total of payments and explain the amount you paid when you have made all scheduled payments. Now, this is, like I said, extraordinarily boring stuff. The fact of the matter is, you need to explain this to the people who are signing the contract. Do it every single time. My grandaunt, who has since deceased, signed a 10-year pre-need with a firm for I think it was $2,500 service. I think it was a memorial cremation or something like that. And my granduncle had something similar. When he passed, after I think 6 years, she asked me to look over her contract. And she said I had like 4 years to pay on this thing. She had paid well into a $6,000 or $7,000 range. By the time she would be done paying, it would be $11,000. No one, quote unquote, no one, explained to her the total amount you'll have paid when you've made all the scheduled payments, even though I'm staring at the number. They just kind of pencil whipped it. You know, sign here, sign here, sign here, sign here, sign here, sign here. Thank you, we're all set. You can rest assured that your wishes will be carried through. Needless to say, called the company, got that fixed. He paid close to $6,900 on a $2,500 service. The total sale price, which is the sum of the cash price, the finance charge, and amount financed by the funeral home, which was not included in the finance charge, is the total sale price. And you must use that term. Explain it as the total price of your purchase on credit, including your down payment. If there is a prepayment penalty or rebate, you must state if there is or is not. Okay? If there is a late payment penalty, you must list it in the amount. If there is a security interest, it must disclose the fact and identify the secured property by type or item. So what happens if you have two people who come in to make this transaction? You know, both children come in, sign a pre-need. Well, you must only give the disclosures to the primary obliger, person paying the most. If the joint and equal, well, only the one. Now think about it. You either are going to have 50-50 or someone paying more than the other. It's not a hard one to figure out. One person either way gets the disclosures. Always provide the consumer with a copy. Keep your original documentation for 2 years. That's a cute number, but realistically, what are we going to do in the funeral home? We're going to take it, stuff it in the pre-need file, and leave it there until it comes due, right? Finally, truth in lending. Over with. Hallelujah. Praise the Lord. Magnuson-Moss Warranty Act governs expressed and implied warranties. You are providing warranties to consumers by selling merchandise, even though you don't manufacture them, right? We talked about warranties in the business law review. Should be nothing new and shocking. When you sell a casket, you are implying the casket will work for the purposes of funeralization. Remember in business law we talked about, or even earlier on in here, we talked about user of the casket. Remember that? Was it the body? Was it the pallbearer who was injured? Laws in different jurisdictions allow sellers to disclaim warranties or not. But you have to do so, if you can, using specific language presented in a clear and conspicuous manner. You should print them in bold on your merchandise price list and statement of goods and services selected. You might want to say it to your client so you have done that. And generally, you are not liable for warranties made by the manufacturers, but you may adopt them by talking too much smack. Okay? If you make certain oral or written representations, you then own it. If you say it's watertight, congratulations. You just owned it. If you do not state that the manufacturer says it is watertight. You're obligated by the Magnuson-Moss Warranty Act to make warranties available to consumers. All sellers of consumer products must make warranties available to prospective buyers prior to sale. Know what the warranty is so you can make an informed consumer decision. You can comply in two ways: conspicuous display of text of warranties in close conjunction to products, or maintain a binder or series of binders which contain the warranties. Binder must be labeled warranties, indexed to products, and updated accordingly. Binder should be in a location with provides the buyer ready to access. I was standing in line at my favorite big box retail store, Walmart, and returning something because it was missing parts. You know how much fun that is when you get home and you start building it and realize it's missing garbage and it's brand new? Oh, it's delightful. Then you go through the experience of going through Walmart customer service. Amazing people stay sane. And there, on a little sign stuffed to the right of the agent, was the Magnuson-Moss Warranty Act, disclaiming that if you wanted to know about a warranty, please ask your customer service representative, and they can provide it for you by printing it on, directly from the internet from the manufacturer. Credit practices regulation. When you enter into a retail installment contract with a consumer over time, you must make sure the instrument is in compliance with credit practices regulation. There are 6 requirements, and there they are. Okay? So, first one, confession of judgment. You cannot issue an instrument that does not allow someone to be heard if they wish to take you to court. You cannot say, nope, you do not retain the right. You can force arbitration first, but generally after arbitration, you have to take a good faith effort in arbitration, and then allow them the opportunity to be heard in court if arbitration fails. You cannot lay claim against personal or real property of a consumer, like a lien on a house, unless it is the subject of a security interest that was listed on the contract. And statutes can supersede some of that. For instance, mechanics can put liens on vehicles, just can put liens on houses, because that is permitted by law. But you just can't walk up as a funeral and say, hey, they stiffed me on the bill, I'm going to slap a lien against their house. It doesn't work like that. Unless they said already they'd be happy to put their house up as collateral. Then, hope it's a nice house. Typically, we can't garnish wages for debt unless the assignment is revocable at the will of the debtor. So if I say, yeah, I can garnish my wages to pay my bill, and then I say, nah, no more, done. Assignment is a payroll deduction plan made at the time of the original transaction, which means they had to do it then, not later. An assignment applies only to wages or other earnings already earned at the time of assignment. So you can't go retroactively looking for cash. You cannot take a security interest in clothing, furniture, applications, radios, televisions, linens, china, crockery, kitchenware, and personal effects, including wedding rings, of the consumer in order to secure payment. Okay, you can't say, give me your big screen. Works of art, electronic equipment, entertainment equipment except one radio and one TV. Antiques, any item over 100 years old, jewelry except wedding rings, are not regarded as household goods and therefore fair game. So you can take a security interest in what they got on their walls. You can take their Xbox or Sony PlayStation. Can't touch their 75-inch TV. It's the only TV they got. If they got a 75-inch and a 23, take the 75, baby. Might as well live in luxury, right? Antiques are that. And wedding rings are generally considered something more than jewelry. Cosigner practices. You may not directly or indirectly misrepresent the nature and extent of a cosigner's liability. Oh, no, you're just signing this just so that we have someone on file to contact if they don't pay the bill. Then they're coming to repoing your car. No. Okay, you can't do that. You cannot obligate the cosigner or misrepresent the nature of their liability without their informed prior consent. There's a disclosure in your book that must be provided to all cosigners. You cannot charge a late fee on payment if the payment was a payment in full on time, or just do not include the late fee from a previous period. That's important. See what that says. If the payment was on time, you can't charge it as late. The bank I do business with was busted for that. They would hold deposits, cause things to bounce, or hold a payment and smack you with a late payment. If it was on time in full, so I didn't give you a partial, I gave you everything on time, and if I did have a late payment that I missed last time, you cannot charge me a late payment on the current one because I just missed the late payment from the last fee. As long as I pay my bill, that late fee can stay in limbo. You might be able to do some more to me, but not just based on that. Folks, thanks for your attention. We will see you next time.